Okay, our fifth panel on first offenders and not alternatives to incarceration. I should say it's our second panel on that subject and fifth panel overall. Includes both Mr. Bendzunas and Mr. Johnson, who have been introduced before, and two new panelists, Michael Andrews and Timothy Purdon. Mr. Andrews is the chair of the Victims Advisory Group. He currently serves as the board of directors for the D.C. Crime Victims Resource Center, as well as the advisory board for the Maryland Crime Victims Resource Center. He has over 15 years' experience in victims' rights advocacy. He has a law degree from Roger Williams University School of Law and an LLM from George Washington University School of Law. Thank you for being with us again today, Mr. Andrews.
Thank you.
Not his first time. Mr. Purdon, is that right?
Purdon.
Purdon is a partner at Robbins Kaplan's LLP in Bismarck, North Dakota, and serves as a member of the Commission's Tribal Issues Advisory Group. He served as U.S. Attorney for the District of North Dakota from 2010 to 2015, during which time he focused his office's efforts on public safety in Indian country and organized crime. He is a graduate of Minnesota State University and Hamline University School of Law. Mr. Bendzunas.
Thank you, Judge Pryor. POAG's been writing about alternatives and first offender for what it seems like 3 years, and it's nice to finally get to present our testimony in person. The core mission of U.S. Probation and Pretrial Services is conducting community supervision. During the past 30 years of the guidelines, we have changed significantly as an agency. In the late 1980s, we were a more reactive law enforcement agency. Our treatment services were limited, and we supervised everyone the same, regardless of the risk they presented. Much has changed in the past 30 years. We have become an outcome-driven and evidence-based agency that leverages risk instruments and now utilize cognitive behavioral therapy methodologies in our supervision practices. It's important to understand this context because I think it informs our position when it comes to the rezoning proposal, and we believe justifies an expansion of straight probation as an alternative to imprisonment. Within the past decade, our national system has adopted a risk assessment that is not only predictive of general recidivism, but identifies those most likely to engage in violent recidivism. Within our strategic plan, we seek to abide by what we call the risk principle, meaning that supervision activities or supervision dosages be commensurate with an offender's objective risk. Research has repeatedly demonstrated that high-intensity interventions on a high-risk case can decrease recidivism. And by these, I mean location monitoring, frequent field contacts, treatment interventions, and participation in reentry courts. These high-intensity interventions imposed on low-risk cases have the opposite effect. It has been shown to increase negative outcomes, rearrest and revocation. With policy demands requiring supervision officers to focus their time and attention on high-risk clientele, POAG is concerned the rezoning proposal will create a conflict between the sentencing guidelines and our risk principle. Normalizing 12-month terms of home detention on cases the guidelines define as low risk will affect our resources, because any location monitoring supervision is resource intensive. LM is a difficult function of our work and has demanding policy requirements. There are mandatory field contacts, 24-hour responsibilities with regard to responding to alerts, and burnout and wellness is an issue for any officer conducting LM supervision. Furthermore, based on the universal feedback we've received from the field, 12 months of location monitoring is simply too long. It's an onerous condition that serves more of a punitive purpose rather than assisting in reentry. There are certainly cases where long terms of location monitoring are appropriate. Those cases are generally not found in zones B and C of the sentencing table. POAG has recommended two possible approaches to increase straight probation sentences produced by the guidelines. The first involves bifurcation of the sentencing table and eliminating the mandate requiring sentencing alternatives to be used to satisfy the low end of the guideline imprisonment range. This would obviously require the Commission to adopt a more expansive interpretation of the 25% rule. So alternatively, we have also recommended authority under 5C 1.1 permitting downward departure where application of home detention or community confinement is not warranted due to a defendant's risk profile. At the heart of our proposal, we seek to bring increased flexibility to the guideline system that is rigid by design. We believe more flexibility within the guidelines will better align with modern supervision practices. With regard to the first offender amendment, as we can see from the last discussion, we struggled to find consensus. We talked about it in probably 4 meetings, and we had a very similar conversation to what the previous panel had. We're essentially equally split between the 2 extremes of the proposal. Our written submission lays out the analysis in more detail, but there are certain drawbacks to each proposal. The broad category, which I'll call criminal history category 0, encompasses a larger population of defendants, some of whom have many non-scoring convictions, including aged-out felonies. The more restrictive category, true first offenders, is a much more narrow classification that could eliminate defendants based on very minor convictions. Critics of this narrow approach express concern rooted in racial and socioeconomic disparity. Officers also raised concerns, like the last panel, regarding first offenders being convicted of long-duration criminal conspiracies, and how you take that into account in the analysis. After several discussions, we resolved these differences in a manner I think Judge Breyer was alluding to in a proposal to modify, or Judge Reeves, I'm sorry, in a proposal to modify 4A 1.3, a downward departure for overstatement of criminal history category. We propose eliminating the current restriction prohibiting courts from departing below criminal history category 1. This modification would allow courts to consider the seriousness of the defendant's criminal history and their likelihood of recidivism. We believe this will allow district courts the ability to reconcile all the differences that we identified. Thank you.
Mr. Johnson.
Thank you, Your Honor. I will stray from my script, which I have a presumption that everyone can read, so.
Rebuttable.
If the commission adopts the proposal that if you have any prior contact, or we'll say start with conviction, that will preclude them from the first offender reduction of 1 or 2 points. The Practitioners Advisory Group asked the commission to consider exempting misdemeanor priors. And that would go part way to addressing the Probation Officers Advisory Group, at least some of their concerns that there are some minor convictions and there are communities where there are more likely to be offenders for almost lifestyle priors that would take them out of the ability to get a 1 or 2 level reduction if they just grown up in a different part of town. I think that's fairly clear in its face, and for those reasons and the others presented, we think that the reduction should not be limited or eliminated for those offenders who have a minor or misdemeanor prior offense. You know, a lot of this discussion revolves around those offenders at the low ends of the guideline range who are not in Zone A. And those are the people who are going to benefit from this and who the court may benefit from by being able to assert more control over them. We have a judge in the Southern District of California that likes to give probationary sentences in some cases because he can impose 5 years of probation, whereas if he imposes a 6 months or 12 months in custody, supervised release then may be limited. So the person will end up under a longer period of court supervision, and then if they violate during the term of that, they can come back and will get resentenced to what they could have gotten, or probably more. That seems to us a more intelligent way to address these offenders who are more or less likely to reoffend statistically than other offenders. They're also more likely to have good jobs, to have families to support, and to not use drugs. Those are important characteristics that probably warrant some consideration for a first offender reduction. I can give an example from our district. 2 different cases, almost identical in facts, both of them charged with alien smuggling. Both young women, about the same age, who had both gotten involved in the smuggling activity because of what they perceived as pressure from someone. while they were visiting Mexico. In both cases, one or two people was put in a compartment in a vehicle. They came across at the exact same port of entry, and they were both arrested, both charged with felony alien smuggling, and both pled guilty, and both had identical guidelines, no prior convictions. Both young women had jobs and aspirations for the future. Now, of course, what we forget in this discussion sometimes is that every single felony conviction, if it's a federal felony conviction, is a mark for life, and that affects their future employment, their ability to earn money, and numerous. There's a website where you can go through all the collateral consequences of federal convictions, and it's in the thousands. And so it is not unpunished simply if they get probation. One of these two young women went to prison for 5 or 6 months. The other one was given probation. And the woman who got 5 months, the judge felt that she had nothing she could do under the guidelines, because the guidelines were what the guidelines were, and that fitting within the guidelines, she wasn't Zone B or Zone A. She could give her a little adjustment in just the time. The other woman got straight probation. And by getting straight probation, saved her job at Macy's, where she's supporting her handicapped mother, and she's very unlikely to reoffend. I think those two women treated disparately. I think the first woman, if the judge had understood that this is a first offender and you can have an adjustment of 1 or 2 levels and zones B and C are combined, she could have come up with an alternative: straight probation, home detention, intermittent confinement, but that was precluded under her view of the guidelines, and so those are other reasons we support it. Thank you very much.
Mr. Andrews.
Thank you, Judge Pryor and members of the Commission. Thank you again for this opportunity to speak to you today on behalf of the Victims Advisory Group. Kind of like my predecessor, Mr. Johnson, we, as the VAG, we had a spirited discussion whether or not a first offender is truly a first offender. I think our consensus was it really depends. I can tell you that the VAG's position is they didn't feel that any amendment needed to be adopted at this point. Kind of like the government's position, they felt there was enough guidance already in the Sentencing Commission for the judges to utilize to determine whether or not a first-time offender is truly a first-time offender. But the premise and the focus of the VAG, however, wasn't so much on option 1 or option 2. The premise was if either one is adopted or strong consideration by this commission, the types of crimes that the VAG would like to be excluded from consideration. And those are any offenses involving crime of violence specified in 4B1.2A1, A2, any type of crime involving a victim or a group of victims that have been identified, burglary, residency, any type of crimes involving minor children, whether it's pornography, or really any type of defendant that has a prior conviction or criminal history points that involve predicated offenses previously involving victims. As presently proposed, the first-time offender can be an individual who has engaged in serious criminal conduct, but not has been criminally charged. For example, a college student has engaged in repeated sexual assaults on campus and who are disciplined by that university, but whose conduct has not been reported to law enforcement, would technically be a first-time offender under the proposed amendments. Likewise, individuals who purchase, view, or distribute child pornography may not have been previously convicted, and again, would technically be qualified as a first-time offender. The exclusion that the VAG purports helps ensure that true distinction is drawn between first-time offenders whose offense conduct did not seek to harm any individual and those offenders who specifically sought to harm others. Finally, if the Commission does not support our exclusion, we would then support option 1 to decrease the offense level for first offenders by 1 level. Thank you, and I look forward to answering your questions.
Mr. Purdon.
Judge Pryor, members of the commission, I want to thank you for the invitation to appear today on behalf of the commission's Tribal Issues Advisory Group. The ability of the TAG to comment on amendments and their impact on Indian country is becoming an important tool for Indian country practitioners and those of us interested in fairness in sentencing and the cases prosecuted in Indian country. I'll note that in addition to my testimony today, we filed a written comment in October of 2017 on this amendment as well. As currently proposed, there are two alternate definitions of first offenders in the amendment. One option defines first offender as a defendant who has no criminal history points. The second option, a person with no prior convictions of any kind. The TIAG believes that either choice could create some unintended consequences for Indian country defendants, and we are advocating for a blended middle course definition of first offender. To understand what I'm saying, you have to understand tribal courts across the country, and they're varied. They vary widely from reservation to reservation. Some of them they routinely handle criminal matters ranging from petty offenses to crimes of violence. Status offenses such as public intoxication, vagrancy, or protective custody are common offenses of convictions in tribal courts, and they can often be used as a means to provide services to the defendant. Public intoxication leads to detox services, but it does produce a conviction in tribal court. Tribal courts also handle serious violent crimes, including misdemeanor domestic violence cases on many reservations. Currently, as you know, tribal convictions are not scored under the guidelines when determining a defendant's criminal history points. The TIAG believes there should be a distinction between petty offenses and crimes of violence in tribal courts in determining whether or not a defendant with a prior tribal court conviction qualifies as a first offender. Take, for example, a scenario where you have two defendants in federal court. Both have two prior convictions in tribal court. One has two prior convictions for public intoxication. Another has two prior convictions for misdemeanor domestic violence. The TIAG believes that those two offenders should be treated differently, despite the fact that none of their previous convictions have produced criminal history points. A definition of first offender that relies solely on criminal history points would allow both of them, including a defendant with multiple prior domestic violence convictions, to be treated as a first offender. A definition of first offender that requires no criminal convictions at all would alternatively exclude someone who has tribal court convictions merely for public drunkenness, public intoxication. We feel that this dichotomy in tribal court is important enough to raise and to highlight all too often, in my experience. Sentencing guideline amendments have unintended consequences for defendants in Indian country and for those 30 or so U.S. attorneys' offices around the country that prosecute violent crimes off the reservation. Our suggestion for an alternate definition of first offender is as follows, and it's in our written submission. A defendant is a first offender if the defendant did not receive any criminal history points from Chapter 4, and the defendant has no prior convictions of any kind except for convictions from trial or foreign jurisdictions which are not for violent crimes. As I want to save time to answer your questions, I'll end there. Thank you.
I'm puzzled by that, Mr. Purdon. So if I had a public intoxication conviction in Alabama, I would not be a first offender, but if I had a tribal one, I would?
Yes. I mean, that is our concern, is that in the...
No, your definition would allow for that, right?
Right. That person would be eligible for treatment as a first offender. If they had nonviolent crimes of conviction in a tribal court, they would be eligible for treatment as a first offender. That's correct.
Even though if they had the same kind of state conviction, they wouldn't be.
When I was U.S. Attorney for North Dakota, I spent a lot of time in front of tribal councils, and I would hear this concern. Crime on my reservation is a problem. Violent crime is a problem. You at the Department of Justice, you, Mr. Purdon, you're not doing enough to make my community safe. We need more resources. We need more prosecutions. And if this was happening in your home in Bismarck, people wouldn't stand for it. Then the next speaker would say, literally, sometimes even the same speaker would say, and another thing, because of our unique sovereign and historical relationship with the United States, when a young offender, someone with a chemical dependency problem, gets in trouble on our reservation, he gets hauled into federal court, he gets stuck with the guidelines, and he often goes to prison for an offense that if he'd occurred off reservation and the state authorities had handled, he wouldn't have gotten prison time for. So both of those concepts, I think, are true in Indian country. That is the issue, and of course, our comments are broader. There are also tribal amendments that you're considering, but that dichotomy of the view of the federal system and the impact in Indian country is different than the person with the public intoxication conviction in Alabama. If they get involved in a fight and beat somebody up, they're still going to be in Alabama state court. The person with the tribal intoxication conviction, if they get into a fight, beat somebody up, they're going to be in federal court under the sentencing guidelines. That's the difference between those two offenders, Your Honor.
That may be. I just don't understand your proposal from the standpoint of treating one as a first offender and the other one as not. I'm not sure you've explained it to me.
Okay.
Questions?
Just one question, Mr. Andrews. I just want to make sure I understand your position. So let me just give you a hypothetical. Take the defendant with criminal history section that indicates violent activity by the defendant, but no convictions, let's say either because things were amended down or dismissed, but there's a clear pattern of domestic violence. What is your position there?
Yeah, our position would be that that individual should not be considered or would not be considered a first-time offender under that. Any type of violence predicate previous history should be excluded.
That would even take into account the fact no convictions, no criminal history points.
Yes, and we debated that long and hard, and that was what I kind of alluded to, is really a first-time offender is truly really not a first-time offender, especially with domestic violence, sexual assault cases, because generally those perpetrators have a history of that violent conduct before they actually are even apprehended.
Thank you.
This is about the proposed departure language that you came up as, because I'm still trying to figure out if that, so just so I understand, the way that the probation officers had in mind, is it essentially to get rid of what is the current prohibition we have now in 4A1.3B2, which, so right now you're not allowed a departure below the lower limit of the applicable guideline range for criminal history category 1, would just be basically to get rid of that, or would it be to get rid of it and replace it with guidance along the lines of some of the things that people suggest? I was just trying to get a sense of when you all discussed it, the resolution you reached, was it just to get rid of it, or was it to get rid of it and also offer some guidance?
Yeah, guidance is always good, so we would definitely, we propose that to be eliminated first, but provide some parameters, give the court some guidance as to what they should be looking at. In terms of some of the things that we talked about today, you know, whether or not a prior offense was essentially an indiscretion, underage drinking, something to that effect, or and also bringing in elements of the instant offense.
Okay, thank you.
Commissioner Boleto, do you have any questions?
I bet it's a really cute baby. Right.
Okay, thank you very much. We have all of your written testimony, too.